My name is Prerna Selvaraj. My matrix number is 10DAT20F2021. Termination by Frankfurtian Doctrine of Frankfurtian. Principal become an enemy alien owing to outbreak of the war the subject matter is lost, destroyed or expropriated, the change of law. Termination by performance. Section 154. Context are 1950. The context of agency is brought to an end when the agency has performed the contract. This can happen when an agency is created for a single specific transaction and the transaction is completed. By revocation, the principal may revoke the authority of the agent at any time before it has been exercised to bind the principal. The principal can revoke the agent's authority where the principal gives notice of termination to the agent or the agent is in default under the agency. Qualification to the principal's right to revoke the agency authority where the agent has carried out the mandate conferred and assumed by the agent.
My name is Janani, daughter of Raghu. My matrix number is 10D8020F2032. Termination by agreement. The authority of an agent may be terminated by the act of the parties by mutual agreement or mutual consent or revocation by the principal. The agency may also be terminated by renunciation of the agency by the agent. When the both parties desire and agree that the agency shall be terminated, then the agency is terminated. The agency relationship is fiduciary one, and so the courts are reluctant to keep parties together if the substratum of the relationship, in particular trust and confidence, has dissipated. In this method of termination, first both the principal and the agent can agree that the agency is come to an end. Secondly, if the agency is evident by a contract, then any provisions regarding the termination of the agency by agreement should be observed by the party wishing to terminate the agency. Thirdly, any time frame concerning the length of notice should be kept. If there is none, then the terminating party should consider giving a reasonable length of notice to the other party. Termination by operation of law. An agency may be revoked by operation of law in any of the circumstances upon the death of the principal or the agent. According to Section 161, Contract Act 1950, an agency which is terminated by the death of the principal is effective only when the agent has notice of the principal death. An exception to the general rule is when the agent has an interest in the property which forms in the subject matter of the agency. In such case, when the principal dies, the agent may continue to exercise authority, and if the agent dies, the authority passes to the agent's personal representative. Secondly, when the principal or agent become insane, the insanity or the mental illness of the agent or the principal also terminates the agency. When the principal become insane, the agent is bound to take all the reasonable steps to protect and preserve his principal interests. Thirdly, when the principal or agent become insolvent or made a bankrupt, upon insolvency, a person's rights and liabilities are vested in the Director General of Insolvency, and therefore the agency relationship ceases.
My name is Tivita Shalila, daughter of Sivanesan. My matrix number 10DAT20F2024. In this case, Azahar is the owner of the biscuits manufacturing company, had always ordered Swan type A quality from the dealer. The further flour was ordered the same flour as previously contract. Azahar was surprised when the biscuits baked by his employee was up to the quality as previously baked biscuits. After a brief investigation, Azahar found out the flour supply did not meet the quality as the usual brand. The issue is whether the quality of the good corresponds with the description in the contract between Azahar and his dealer or not. Based on this case, the suitable provision is Section 15, Sales of Goods Act 1957, which is sale by description, where there is a contract for the sale of goods by description. There is implied condition that the good shall correspond with description, and if the sale by the sample as well as by description. It is not sufficient that the bulk of the goods correspond with the sample if the goods do not also correspond with the description. There is a case stated on this provision, which is Nagodas Purushottam Das and Co. vs. Mitsui Bussan Kaisha. In this case, a contract of sale was made between two parties in a sale of a well-known type of flour. After the buyer ran out of such flour, he made an order description. It is the same as our previous contract. The seller delivered flour identical in quality as the previous one, but of the different brand. It was held that the seller did not comply with the buyer's stipulated description. In conclusion, the case on point is Nagodas Purushottam Das and Co. vs. Mitsui Bussan Kaisa Ltd. Applying this case, it appears that the dealer has breached a condition of the contract. This entitled the innocent party, Azahar, to repudiate the contract. Other cases on point include Bill vs. Taylor and Associated Matters Ltd vs. Tam Chioto. However, Azahar cannot repudiate the contract but can merely claim damages if they have waived the conditions or they have elected to treat the breach of condition as a breach of warranty and claim damages only. Where the contract of sales is not severable and they have accepted as breach of warranty unless otherwise provided in the contract. According to the fact in the instant case, Azahar can repudiate the case contract as they have not done any of the above.